following the script, the questions that we were planning to discuss today, I would like you to comment. You mentioned before, Jean-Philippe, on the concept of user. I would like to understand what it's in your jurisdiction, what it's deemed to be it's understood to be the concept of established person, how it is interpreted for yacht owners and operators in terms of the owners and as well potentially of users, which the temporary admission regime allows the use of yachts in certain circumstances by EU residents and non-EU residents. But the concept of being established a resident, it's an aspect that might differ from one jurisdiction and another. And I would like to get your insight from your local perspective. Yeah. Christine, if you could please comment.
Well, with respect to the owner and the user, the customs would normally will look at evidence to confirm that the user or the owner is actually non-EU. Usually, they would look at the residency and not the nationality, because as what the law says is the person established outside the EU. Now, when you say established, it normally means where does that person have his habitual residence if we're talking about an individual. So normally they would even request a tax residence certificate to ensure that it confirms if, for example, the address is different to his passport, for example. So they would go into certain detail to ensure, and they obtain comfort that the user and the owner is actually a non-EU resident. So there will be sort of various documentation to confirm that. So if they had to go into dig deeper, they would need to understand, for example, where is his day-to-day business, where is his family, where are the schools of the children. But normally they do not go into such detail because normally they feel quite comfortable with what they obtain. But if necessary, they will have to look into as well these aspects.
Jean-Philippe, what's your experience in France?
Well, as Christine said, the law says that you're established where you have your habitual residence. But what's a habitual residence? Well, the case law says that it's where you have your normal residence. So we're going in circles because we still don't know what's a residence. And then the further case law on this says that, well, you have one entire paragraph of guiding factors and issues which you could take into consideration: primacy given to personal ties, where the children are schooled, a willingness to reside in a country. And you see that it is very insubstantial. You don't really know what it looks like, a normal place of residence. And so you have discussions with the authorities on, especially when people are in between two countries. And we know that a lot of our clients in the industry move a lot and don't reside necessarily in a fixed location. So you have these discussions on, do they have more of their business in the EU or outside the EU? Yeah, when they have 2, 3, 4 children, some of them are schooled outside the EU, some of them are schooled inside the EU. And you don't really know how to analyze all this, and you're left with an uncertainty on the discussions. In France, we're lucky because we have 1 or 2 decisions from the Supreme Court that seem to give the period of stay as a prevailing factor. So if you're staying less than the magical 183 days in the EU, you seem to be considered as a non-EU resident. Or you stay more than that period, you seem to be considered as an EU resident for the purposes of customs legislation, of course. Except that sometimes the court, when they cannot find the real period of stay, they tend to fall back on where next of kin and family ties are located. So for us in France, mainly it is how long you're staying in France or in the EU globally. And to do this, we look at passports, notably. So customs will ask for a full copy of the passport and to note the entry and exit stamps from the EU. And you count the number of days in between. And if over the year you're more than After a year in the EU, you're considered as an EU resident for the purpose of the customs legislation, and you're not eligible for TA. If you spend less than that period, you're eligible for TA. Of course, you still have to determine who the real user is, but at least for the residency, we have more proper guidelines and a quick referral to the passport.
Carla, what's the reality in Italy?
There are no written practices on this, but the main streamline is that the place of establishment is considered the tax residence, so close to the center of vital interest, and the investigations and checks are close to what Christine pointed out in terms of school, main house, and we noted that the tax police and controls have been done also by using social communications done on social means of communications with the personal audience of people. And a problem we identified, going back to what also Jean-Philippe pointed out in terms of identification of the user of a yacht, is because sometimes the deal and the decisions, strategic decisions in terms of also the customs status and customs regime of a yacht are done with attention to the ultimate beneficial owner of the company, which is the owner of the yacht. But usually we can find that there are many situations where the ultimate beneficial owner of the owner company is not on board, and maybe his wife or her husband or the partner or friends stay on board without the ultimate beneficial owner of the owner company. So it's very difficult in terms of strategy, building an appropriate strategy for these cases, that we can claim that the user of the yacht is someone which is not found on board in the case of controls. And we have to be prepared in terms of setting up of the strategy, of the custom strategy of a yacht, to consider which can be the normal situations where a control may occur, and maybe there is just another person, and we know that whilst families and a group of friends may have different passports, different residence, place of residence, etc. So this can trigger unexpected issues if we just think about the situation in terms of ultimate beneficial owner or the owner company.
Mm-hmm. If I could add from a Spanish perspective, I would probably say that the concept of established, I certainly would differentiate in between legal entities and individuals. Obviously, legal entities, customs tend to check if it's obviously a corporation incorporated outside the EU customs area, and in addition, check the status of the ultimate beneficial owner, whether that individual behind the whole structure as well qualifies to be eligible for the customs regime. And in terms of individuals, I would probably align with the comments that you shared here with us. And it's the basic rule, it's 183 days in the customs area. However, there is some inconsistency from a Spanish perspective, because despite a person might be eligible for, let's say, VAT exemption or customs exemption from a VAT exemption from a customs standpoint, not spending more than 183 days, like individuals holding golden visas, for instance, on this kind of immigration programs. Despite these persons can be eligible for exemption on VAT, they could be trapped under the Spanish matriculation tax, which works slightly different, but it's somehow as well related with the exemptions granted to the temporary admission customs regime. In Spain, a yacht that benefits, or an individual or corporation that it's eligible for this regime, will be exempt not only from VAT, but as well from the Spanish matriculation tax, which for those of one which are not familiar with this tax, it's assessed at 12% on the 12% on the yacht value. So it's a very significant tax. So as I said, it's a slightly inconsistent because sometimes a specific individual can be exempt of VAT, but can be trapped into matriculation tax. So it's an aspect to which is certainly a peculiarity of Spain. Moving on into the list of questions, the points that we want to cover today, I would like to ask you from an operational perspective, does